Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
Defense Department employees have become the latest group to lose their protections provided under collective bargaining agreements as the Trump administration continues to strip workers of their union rights at agencies with national security missions. But unions say they have represented federal workers for decades, have successfully challenged similar efforts in the past, and will continue to fight the move. For more, Federal News Network's Anastasia Obis spoke with Ira Rushing from the Tully Rinckey law firm.
With this particular situation and the lawsuits and what they're trying to do, it starts from some pretty explicit statutory authority that President Trump has and that every president's had for a long time. And it's this 5 U.S.C. 7103. And that statute allows the president to essentially exclude any agency or subdivision from the federal labor relations statute if its primary function involves intelligence, counterintelligence, investigative, or national security work, and when collective bargaining can't be applied consistent with kind of national security requirements, right? So this exemption was written into the Civil Service Reform Act. I think it's like 1978, but it's the Civil Service Reform Act, and it's never been repealed. And so the president is the one that we all elect to make national security judgments. And because of that, the idea is that courts owe substantial deference to those judgments, right? So from reading the litigation in California and in the Ninth Circuit, it seems like the administration's general position is that the modern threats, the modern foreign and domestic threats that we see have kind of expanded what counts as national security work. And there's some legitimate arguments to be made there. You know, the battlefield landscape is changing. And so that forces us to be responsive in a fast moving way. And for good reasons, a lot of the time, our government's not set up to respond quickly to things that are happening. So the DoD obviously falls under that, but also the agencies that secure the border, enforce federal law, which we see with like ICE and DHS and things, protect infrastructure, regulate dangerous substances, so like the drug, the DEA, things like that, disaster response, so FEMA, and run cyber and intelligence, stuff like that, NSA. So all these agencies kind of fall under what the administration thinks is now national security work. And so the position that they're having against a union is that a union has the ability to kind of slow walk these critical decisions through grievance procedures, and they can force arbitration, and they can tie up management in bargaining over changes. Realistically, that's operationally incompatible with national security responsiveness, right? Like some of these things require decisions made quickly. And if you don't make them in a way that is conducive to the feelings a lot of times of employees, then collective bargaining slows that down. That's the historic fight that we've had against unions. And what the administration is pointing at is that the president has used this before and it wasn't an issue, right? Like, so President Carter, he excluded parts of the NSA. Reagan famously, and that was the big thing, is like Reagan excluded the Marine Corps marksmanship unit, right, from all of these things, which was wild. And then Bush 43 excluded like certain parts of the Justice Department. So the legal mechanism's not new. What's new is the scope. And so the administration's response is essentially saying what the scope is a policy judgment committed to the executive branch, and Congress gave us that judgment because it wrote it in statute. And that's the administration's position. And the union has, smartly come back and said, okay, well, we have a couple arguments of our own, and their main argument is ultra vires, right? So they're saying that this statute is a narrow carve out. It's not a blank check, right? Congress wrote it for agencies with intelligence and national security work as their primary function. And so bringing in all of these other agencies and subdivisions whose primary functions are like regulatory or scientific, right? Like think the EPA or the FDA or the CDC, things like that. that stretches the statute past its breaking point. And so the unions are saying, look, the president can't use this narrow exception to swallow the whole rule that Congress established for the rest of the federal workforce, right? There has to be a line, there has to be a limit. And then the major federal government's employees union, their big argument is First Amendment retaliation. And that's what the court recently kind of struck down.
You mentioned the American Federation of Government Employees. They are the largest federal employee union representing DoD workers. I think the number is 300,000. But we're talking about 9/11. We're talking the war in Iraq, Afghanistan. We're talking the workforce working through presidents from both parties. So the question is, what's changed? You mentioned it's been applied narrowly. However, this is extremely widespread right now. So what's really changed now? What's underneath this?
It's a good question. I think that's the question that separates what's happened in the legal fight from kind of the political reality. And the legal fight is all about the statutory text. And the political reality is, why is this administration doing anything that it's doing to push laws this far when prior administrations didn't? And there's a couple. The administration's stated rationale in the Ninth Circuit which was accepted by the Ninth Circuit, was that this recent executive order has a legitimate grounding in national security concerns, and that union activity and collective bargaining has an impact on, I guess, the sound operation of agencies and subdivisions with national security-related missions. Basically, stripped of all the legalese, the administration's saying the CBA slows agencies down, and the realities of the modern battlefield and national security concerns are just operating at such a quicker pace than they ever have before. I mean, at exponentially, like every year that goes by, things are changing quicker than they did the prior year. I mean, the battlefield now wasn't even conceivable when Bush 43 was president. And so what the administration is saying is we're not stripping these CBA agreements or the collective bargaining agreements because we hate federal workers. They're saying it's hard for us to respond as quickly as we need to very abrupt and acute national security concerns with these CBAs in place because it just slows us down so much. And I think that's a very logical and rational thought. I think kind of the more candid policy answer is that I think something the administration and its allies probably articulate pretty openly is that, realistically, the president wants to manage the federal workforce more aggressively. He wants to hire faster. He wants to fire faster, reassign faster, change duty stations, right? It's, the boomer generations across all industries that are like, telework is bad. If I can't see you physically in the office, then I just assume that you're incompetent and lazy. And they want to end telework, reduce headcount. That's a big Republican policy narrative is big government bad. And so removing the CBA doesn't just remove the union, it removes this procedural friction that the union enforces. That's kind of the big difference.
You talked about the workforce and kind of everything that they will lose and the protections they will still have. But in terms of the immediate impact, could you talk about what this actually means for the workers today? What changes for them right away?
Nothing really today, because nothing's really going into effect today. But I would say, the most immediate change is going to be procedural, not substantive. So like, yesterday, a DoD employee with a workplace problem went to the union representative. Today, that pathway is just closing a little bit. I think what's going to happen immediately is that negotiated grievances, they'll stop being filed and accepted. I think we talked earlier, I think existing grievances in the pipeline will either get held in abeyance or dismissed or maybe just kind of die a quiet death, depending on the agency and what stage it's in. Or maybe arbitration hearings get canceled or postponed indefinitely. I think that's where the litigation piece is going to come in, but that's not going to happen today.
That's Tully Rinckey's Ira Rushing, speaking with Federal News Network's Anastasia Obis. You can find her story at federalnewsnetwork.com.